take on that, please?
Well, usually what the government's going to want to do in the rebuttal is tie up any loose ends that the defense would have pointed out. Usually those all go to reasonable doubt, and specifically they'll go to areas within certain charges that the government, if they cannot prove well, means you have to dismiss. Now, in this case, though, look at the evidence. I mean, when you look at the amount of evidence that ties this person there with no other possible suspects to having been the perpetrator, there's no need for the government to spend the kind of time that this prosecutor did on the minutia. What you usually see is an experienced prosecutor who is well seasoned in the art of trial advocacy will spend a lot of time on the moral imperative as to what it means and why and how they should feel about it without arguing it as much as, if you will, telling the story. So what you really were just listening to was someone going through a long narrative of a very long list of facts with no way to knit them together. And I guess the idea or the strategy behind doing that was probably along the lines of just overwhelming the jury. But at some point, you really got to make sure you respect them and honor the jury and realize enough is enough and give them the case and let them deliberate. They know what you need, they know what you want, they know what they've seen.
Yes, so well said, Attorney Joseph Lowe, so well said. Hashtag sit down is what I say sometimes when you see good attorneys, right? And we definitely see eye to eye on this. When you see good attorneys, who obviously this is a very capable, bright, seasoned prosecuting attorney who's tried this case beautifully up to this point. But sometimes it's really key in knowing when to sit down, knowing when to say, okay, this jury has heard enough. And for me, I really felt like it was just repetitive storytelling. And I thought her co-counsel just knocked it out of the park with the state's close. I thought there was really nothing to tie up, maybe just a little bit about that notebook, the notebook and addressing that, because the defense really picked up on that and why certain things weren't tested, right, in terms of the DNA. Your thoughts? Do you think that's maybe what she would have wanted to just hit home on and then have a seat, or anything else you thought might have been a loose end needing tying up?
Well, maybe if we're kind and generous in our comments. Look, if the other prosecutor did as well, you know, in everyone else's eyes as they did in ours, it's going to be intimidating for that prosecutor not to get up and want to have something to say as well. And this is what happens, honestly, when you end up having a camera in the courtroom, is some people just cannot resist the urge to show off. And to me, that is really disrespectful of the jury. If you are truly in tune with a trial, you have no energy wasted on you or what you need or what you're feeling. You're spending all the time watching the jurors, connecting with them, and making sure you are serving their needs, most of which, at the end of the trial, is trusting them enough to do exactly what you said, which is to sit down and have nothing else to say. You've done what you meant to do.
Yes. And of course, you make a great point. You want to be cognizant of the jury's time. You want them to like you. You want them to be on your side when they go back to deliberate. And tell me, Joe, last question before we're going to go in there and play some of the jury instructions for everyone. But do you think this could be a record verdict in terms of time? What do you predict in terms of the amount of time this jury is going to spend in that deliberation room?
I don't know what the record is, or I don't know what it is in that state. However, I would be very surprised if this doesn't come back quickly. However, when you do have a lot of facts such as these, and they are gruesome, unusually gruesome, such as these, and then you have a young child who's done this, you know, to their parents. Of course, he's an adult now in graduate school, but all of those things are very emotional, and so the jury is going to want to talk about them, not figure them out, not to, you know, have point counterpoint. It's just so emotional that a lot of people are going to want to say something about that. They've been forced to listen. So don't be surprised if it goes a little bit longer than maybe you would normally guess. It's because of the huge emotional content of it.
Yeah, that's a really great point, because those jurors will be doing what they should do, right? And that's talking about the case, talking about the facts and what they've heard when they finally go in there and deliberate. All right, civil rights attorney Joseph Lowe, great getting your insight on things. Thank you so much.